So basically, if you have your guns, they either need to be on you under tamper-resistant lock, so like a trigger lock, or they need to be in a safe.
Yeah, and then be careful who has access to the safe.
Exactly, yeah. I mean, because if the safe could be accessed by other people, then if I remember correctly, the main challenge was that you had to provide a justification for your license.
Single words can have a huge amount of meaning because the way that the courts look at it is they give the legislature a lot of credit and they say they must have meant every single thing they put in here, and anything they didn't put in on purpose.
When I practiced in Alabama, it was a shall issue state. And there's basically this back door, though, is like it shall issue unless the chief believes that you're a threat to public safety. Or unless the chief... Yeah, exactly. Like it sounds right. It's like, oh, shall issue. That's what matters. But then what matters is what comes after it. Welcome to episode 6 of Boston Barristers. I'm here with Chris, and we're talking about the 2024 and 2025 updates with the license to carry in Massachusetts. How are you doing, Chris?
Doing great, Matthew. Thank you for asking. Can't wait to get started talking about the updates to the gun laws.
Yeah, so just when we feel like we know everything, everyone changes it. The U.S. Supreme Court, the Massachusetts legislature, and then the Massachusetts SJC, they just change everything, and we're stuck scrambling again.
Yeah, I always feel like I know everything. I never feel like I have no idea what's going on.
Well, that's why I'm asking you the questions today. So how about
see how that goes.
So I feel like this all started with the Supreme Court's decision in Bruin. What happened in Bruin? What was the basics of how it started, and what came out of it?
So my memory of the Bruin case is I actually listened to some of the oral argument that they were having in front of the Supreme Court before the decision came out, and they paid a lot of decent homage to the Heller case and, recognizing stare decisis. And it was really interesting to watch because Heller was a big deal when Heller came out, right?
Oh, yeah.
This is the DC case about handguns where the court was like, no, you can do kind of whatever you want. And by the time we get around to Bruin, they're like, oh, yeah, that's definitely well-settled law. No going back on that one. And so with Bruin, as I recall, there was an issue with the may issue language around different states have different regimes for how licenses can be handed out for firearms. And the issue, I believe that the one that I remember most distinctly listening to in the oral argument was New York is a big state. And so there may be different reason for different application of the law in upstate New York versus what kind of firearms do you want somebody to have access to in Times Square? And the court said, we hate that, and we're not going to do it. There is no difference geographically. The law is the law is the law. Moreover, New York, you can go pound sand because we are the law of the land, and we will tell you it's a shall issue, and that's the way that it's going to go. That's my memory of it. What's your memory of Bruin?
So, yeah, I mean, it was a challenge to the New York regime. And I think if I remember correctly, the main challenge was that you had to provide a justification for your license. And you had to say, like, here's why I want a firearm. And the Supreme Court said, no, you can't do that. You can't make people justify the exercise of their constitutional rights. Like, I don't have to go to the government and say, hey, I would like to go worship in church today, and they don't get to ask me why. I don't have to justify to them that I want to go to church or that I want to publish a newspaper or that I want to speak freely. So if I remember correctly, that was the main thing in Bruin was about that. But you're right that there was I think one of the concurrences talked about the may issue versus shall issue, but basically there's a discretion, usually the police department, to say, no, you can't get a license to carry. Whereas a shall issue state is... Today's episode is brought to you by the Law Office of Matthew W. Peterson. If you're facing legal trouble in Massachusetts, whether it's an OUI, a firearm charge, or even just a clerk magistrate hearing, the stakes couldn't be higher. This isn't the time to go at it alone. You need more than just a lawyer. You need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts turn to the Law Office of Matthew W. Peterson. With years of experience in criminal defense, family law, and immigration, we've got the track record and the passion to defend your rights. We've successfully represented clients in some of the toughest situations out there, from first-time offenses to serious felony charges. We've helped people protect their record, their families, and their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule your consultation or call 617-295-7500. That's mwpetersonlaw.com and 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal. Now, back to the show. So why don't we talk about that? Like, what's the difference between a may issue and a shall issue?
I mean, the may shall language is something that you see in a lot of different areas of law. And it is, kind of like conjunctive and disjunctive lists. It's sort of, there's a way that things are written when they are the law. And it's one of these funny things where if you're like a legally, you're kind of a nerd, you like to see the way that the law shakes out. Single words can have a huge amount of meaning because there's sort of the way that the courts look at it is they give the legislature a lot of credit and they say they must have meant every single thing they put in here, and anything they didn't put in on purpose. And this gets into stuff like, if you remember Roper v. Simmons in the Eighth Amendment case, where it's like cruel and unusual punishment. It's like it has to be cruel and unusual to violate.
Oh, yeah.
It could be cruel if it's not. If everybody does it, and it can be unusual as long as it's not cruel. So there's a juvenile death penalty case from, I think, like 2003. So stuff like that is where may shall becomes super interesting because it's like when you have a may issue, it totally blows open the idea that you have a constitutional right to this thing. If someone may take away that right from you. Whereas shall issue is much more in line, I think, with what we all understand the Bill of Rights to be, which is like, you have to do this. Like, unless there is another law that conflicts with this, there's no real discretion here. And so it's also easy to understand may versus shall as like, shall's a hard line, right? Like you start with the presumption that it's going to happen. And then if there's a reason that it can't happen, then we get into that. But may is like, maybe you honor this right, maybe you don't. Do you have a reason? Do you not? Do you need one? And so may is very, like, it's nebulous, I think is a legal term that we sometimes use, like really hard to pin down. But shall has a very fixed point, and then from there you kind of go. And so it's amazing we lived with may issue for as long as we did, frankly. But
yeah, it's funny. I mean, I do think that there's a lot of distinction between may issue and shall issue. Like if you read blogs and what other people talk about it, they're like, oh, we want to be a shall issue state, we want to be a may issue, like whatever. When I practiced in Alabama, it was a shall issue state, and there's basically this back door though, is like it shall issue unless the chief believes that you're a threat to public safety. Or unless the chief exactly, like it sounds right. It's like, oh, shall issue, that's what matters, but then what matters is what comes after it. Right. So here, like everyone makes a big deal about it. I don't really think there's that much difference, to be honest with you. I mean, this may be
shall
in this context, because we're kind of skipping ahead here, but Massachusetts switched to a shall issue state, but it's still shall issue if the chief finds you suitable. Yeah. So it's like, it's not really a shall, but anyway, the case I had in Alabama, it was like this guy had a marijuana case, and the chief was like, oh no, I'm denying you because I find that you're a drug addicted person. And I filed this petition in Alabama district court, and like they had never seen it before. Like the clerk's office called me up and they're like, what is this? I'm like, so go to the statute and you can read it. Like there wasn't a category in it for e-filing it and all this stuff. And so that was my kind of first exposure to it. It was like, oh man, we're talking about like 10 years ago now.
The thing I think to answer your point that may and shall may not be different, I think, again, I don't want to jump ahead either, but I think that the decisions we plan to talk about that came out this year, I think put a harder line on what shall has to mean. Like if you're going to backdoor, if you're going to say shall, but like there needs to be something fixed and legal about that. It can't be shall issue unless the chief has a weird feeling about you, right? Like because then you're in may territory again. Then you've to use a legal term, you vitiated the purpose of shall issue if you've given a bunch of weird caveats. And so I think that's where Marquis and Donnell come out, is they're like, it's not that loose, right? Like we have to pay some respect to the fact that the law exists in this context.
So that's why you can tell I'm working with a true pro here today, because that is what we call a teaser. And teaser.
Pay attention, because later in the podcast it could come back up. We teased the Marquis Donnell thing, but I don't want to get too far ahead of ourselves because I think we have to go back. Marquis and Donnell, when you read it, they talk about Bruin. So we need to really get a better sense for like where Bruin came out. And since Matthew, I think you've been looking at this a lot longer than I have, why don't you give us a sense of where Bruin really landed?
So yeah, Bruin, the Second Amendment has to be one of the weirdest drafted amendments in the Constitution. Like you have this thing about a well-regulated militia, and then all of a sudden it goes into you have a right to bear arms. So there's been this whole push and pull, like you talk about the Heller case, you talk about other cases, talk about how does the well-regulated militia play into the right to carry firearms? And Bruin settles that. I mean, Heller did to a certain extent, but Bruin says, yeah, the Second Amendment, it applies to an individual's right to carry guns. And any regulation of that has to pass the standard. It has to be justified by historical precedent in colonial times, which is, I feel like, I mean, not to get into Supreme Court justices here, but like Scalia loves this sort of thing, right? Like going back to what was the founding understanding of the Second Amendment and what was the founding understanding of what is a proper regulation of it. So basically the thing is you look at, was there a historical precedent for this particular regulation of someone's firearms rights? First, does it implicate the Second Amendment? And then is there a historical precedent for it? And it sort of creates that framework for any sort of thing dealing with gun laws, is looking at what is the historical precedent for it. Can we go back to the late 1700s and find something that looks like it? I mean, the problem with it is that there were still millions of people living here. There were different cities and states and all of that back then. So it's kind of one of those, you know, one person can look at the history and find one thing and the other person can look at the history and find something else. You deal with all these weird like bond statutes where if you had a gun, you had to like post a bond or something like this. So yeah, I mean, that's basically what Bruin did. But the upshot is that in Massachusetts, and this is a crazy thing, in Massachusetts, there are cases that said that there was no individual right to carry guns, right? So you did not have a right to carry guns in Massachusetts. And this kind of forced Massachusetts to say the Second Amendment means what the Second Amendment says, which is that it protects an individual's right to carry a firearm in Massachusetts. And there were cases that came out after that that talked about solidifying that individual right in Massachusetts.
Okay. And I don't want to derail us too aggressively here. I think it's an interesting departure point, just because there may be people listening who have different, you know, opinions on this sort of thing. And one of the people who did and who will not be listening to it, obviously, is Justice Stevens. But Justice Stevens had a pretty aggressive, I think it was something he published after he left the court, but he really did not appreciate the throwing out of the first few words of the Second Amendment. He was like, you can't just, and this is kind of, again, this is a callback now to what we talked about earlier, where words have meaning. You know, statutory construction typically deals with things like primacy, which means like the most important language is in the front. And as you pointed out earlier, you know, the Second Amendment's weird because there aren't, you know, it's searching my mind here. We know why the Third Amendment exists, and it's because the British were quartering troops in people's houses. But it doesn't say in the Third Amendment, thanks to the British, no more soldiers in private homes. The First Amendment doesn't say tyrants hate free speech, so we need free speech. The Second Amendment says, because you need well-regulated militias, you can't take away people's guns.
Right.
And it's sort of that it has a justification in there. Could be an artifact of the, you know, people who wrote this thing couldn't agree about the Second Amendment until they put a justification in there for it. But and that may be where we've landed, right? But the court is essentially said, we're going to ignore those words, right? And that's where we are. And again, I think Justice Stevens has a disagreement with that. It feels like at this point, especially with the Marquis and Donnell, like it's trickled down now into the states. Like it's gone. And I don't think that it's well beyond the scope of this discussion for us to talk about, you know, originalism and strict constructionists and textualists and, you know, all the other different ways that the courts and legal academics have decided to hash these things out. But I think it's worth keeping in mind that where we are now is pretty far away from where we were like 20 years ago.
Oh, yeah, definitely. I mean, I think if I remember Heller right, it was about whether you can prohibit guns entirely in DC. Like DC was like, you can't even have a gun in your house. And Heller was like, oh, no, I think
in my memory, Heller was DC banned handguns because of the rate of handgun violence. And the court was just like, absolutely not. Like, we will not, whatever security or public safety concerns you have can just, you know, it says right there, shall not be infringed. The right to keep and bear arms shall not be infringed. And that, look, I mean, it does say that. There's no arguing it. I mean, there's the first part, but who knows what a well-regulated militia looks like anymore?
I mean,
what
so
even
basically,
is the National Guard?
Yeah. I mean, so I think that the headline here, I mean, I know that, Second Amendment enthusiasts who are also familiar with law and wanted to hear about contextualism. But Bruin basically said there is a Second Amendment right to carry guns. It settled that debate about well-regulated militia. And it forced Massachusetts to say, yeah, there is a Second Amendment right to carry guns. Because before that, it was like, there were cases that said no. There were cases that said, if the government wants to take away your guns, they can. And Bruin forever settled that debate. So then it sort of had this sea change effect across the country where we're looking at statutes from the 1780s or whatever. And then I feel like Massachusetts, one of the things they reacted to that was this 2024 Firearms Act that went into effect last October. I know that everyone was freaking out about the different things that it was going to cause and different ripple effects for gun owners here in the Bay State. So what are the main provisions of that 2024 law and how they played out?
So in 2024, this is the massive overhaul is how it was essentially pitched. It's a bit of legislation from, I think, July of last year, where it expanded considerably regulations on firearms, ammunition, the kind of accessories you hear about on the news, like bump stocks and stuff like that. Honestly, terms that if you don't deal directly in firearms, like you might not be familiar with what a lot of these, if you're a hobbyist or an enthusiast, you might know, and have a better sense of what these things are, what's now been outlawed, what's considered a firearm. And that really is some stuff that might blow your mind about it, is that there were like the definition of firearms.
Yeah. So
last year, right? Isn't that
yeah. So like,
crazy?
I think firearm is something that looks kind of like this. You pull the trigger, something comes out, it says boom. What is a firearm according to this 2024 law?
So just in honor of the fact that we've been talking a lot about language and what it has to do with the law, and I may get this not entirely right, but one of the issues was that historically the laws referred to firearms, I think long guns and shotguns maybe. There was a repeated use of language that had firearms separate from things like rifles, which was very strange because it was like, all right, well then every time you regulate firearms, does that not include rifles? Because rifles is separate from firearms in some of the language.
Oh, yeah.
And as you and I both well know from having practiced in Massachusetts, like because of the common law and because of how old the Commonwealth is, there's so much that has just over time been kind of like pasted together, right? Like, and just, it's sort of this, it's just over, like it's things have been layered and layered over time. It wasn't like somebody set out to design this from scratch. So what they now do is the act from last year says that pistols, revolvers, shotguns, rifles, machine guns, any weapon that can fire a projectile or from which bullets can be discharged. And this matters in an era of 3D printing for reasons that our audience can probably appreciate. Anything that may have escaped regulation before, because it wasn't like clearly within the confines of the law, is now meant to be captured. Things about, and this is, if you're interested in this kind of thing, you should look into it. When you have enough of the parts to make a gun, when are you illegally in possession of a gun? Right? So it's different, meaning if you're holding an assault rifle or a machine gun, versus you have 10 machined parts on your table that, under the right circumstances, and if you knew how to put them together, could be an illegal weapon. Are they now illegal? And the answer may surprise you. So that's again what this was meant to do, was sort of like an omnibus push to capture a lot of stuff that, as technology has developed, certain things have come into existence that the law didn't necessarily capture. And I think what you have to keep in mind is the legislature, in light of all the stuff we've talked about just now, like the last 15 or 20 minutes, where nationally and federally, there's an expansion of ownership, individual ownership rights. And if the law isn't careful about what is constrained, the courts are going to be obligated to just err on the side of, well, no, I mean, if it's not expressly illegal, we're not going to give you the benefit of the doubt. A person can have X or Y or Z. So the law is essentially an answer to that. And this is counterintuitive, right? Because we spent the last 15 or 20 minutes talking about the expansion of firearms rights. But this law, and I wouldn't call it an attack, I think a lot of people did, it was not meant to follow what has happened with the Supreme Court. It was meant to try, I think almost you could say, protect from a overbroad reading. And do you agree with that? Yeah. Do you think that you're...
Yeah, I mean, I do see it as kind of a direct reaction to the Bruin stuff and the more federal trends in the opposite direction is Massachusetts trying to say, well, no, we still have the right to regulate these things. And obviously, like, we're not going to be able to get into the whole thing. If you want to read the statute, you can. If you want to consult with us about your specific situation, we can talk to you about it. But this is not, obviously, we're not going to sit here and read it and go through every single permutation, because then I think this might be a 10-hour podcast.
It's a long bill.
Yeah. So then one thing it did is expanded the definition of firearms. What about assault weapons? Like, I feel like assault weapons is assault weapons just means a gun that looks scary in popular imagination.
Right.
But how did it change the definition there?
So I think it seeks to close like loopholes that some weapons were probably designed to get around a ban on, like Massachusetts prior ban on assault rifles. You'd say, well, what if I have like small modifications to it? Then it's not going to fall into the category that currently exists. And now they're like, all right, well, we're closing that loophole too, because you caught us. I mean, one that I think a lot of people are surprised about and is now even harsher, I guess, than it was, is if you have a magazine capable of holding more than 10 rounds, it better have been produced prior to 1992, I think it is. 92 or 94. Do you know which year off the top of your head?
Yeah, because it was the federal assault weapons ban that's now expired. But it was 92, it's somewhere in the 90s. I think you're right.
And so if you have and you'll sometimes see if you're shopping for them, they'll say this is a pre-ban, magazine, so you can legally possess it. But if it's, one thing that you and I have both seen plenty of times, we get clients who maybe they live in New Hampshire and they buy something perfectly legally at a gun store, and then they move just south of the border, they bring it with them, and now they're in for a real serious headache if and when law enforcement comes upon that magazine capable of holding more than 10 rounds. So what this did is it tried to catch up to modern technology with assault weapons. And I think it probably also tried to catch up with any end runs around the 10-round restriction for magazines.
Yeah, and the magazine stuff is so tough too, because I mean, I've had clients who had magazines are like, no, this is pre-ban. The problem is they don't have serial numbers. So there's no way to conclusively say whether a magazine was pre-ban or post-ban. So it was a really unworkable formula. What about background checks? How did it change background checks?
So closing the private sale loophole. So you need background checks for basically any firearm transfers. Some limited exceptions continue to exist. Immediate family members, I think temporary transfers. But, private.
So that means that like I don't have to do a background check if I give it to a family member, but otherwise I do have to know who I'm giving a gun to.
Right. And that, again, was I still remember a time when you could buy a firearm from a friend of yours, but now licensed dealers conducting background checks. There's also a lot in there about information sharing between state and federal authorities, because as I think is probably going to be the content of a different blog, or a different podcast, disqualifiers, things that make you statutorily ineligible to have a license to carry. If that information comes from a different state and there's not adequate information sharing, what's the point of the law? So I think that the law tried to essentially enhance some of that as well.
So another thing that the act did is it changed, and people were kind of freaking out about this, it changed the firearm safety course. Because when I did it, I did live fire, but now that's actually required for everybody.
Yeah, I got my license like 21 years ago, and in the town I was living in, did not have to do live fire. So I think that is something that people probably will freak out about if they don't have a lot of experience or if they're not specifically confident in their ability. But I mean, maybe you can kind of demystify that for them. Since I didn't have to do one, my sense is that it's probably not going to be like, can you hit a nickel at 100 yards? It's going to be like, can you do this without blowing your foot off? Do you show muzzle? Do you have muzzle and trigger discipline, like proper handling?
Yeah, I mean, when I did it, I think one of the big things is you have to actually handle a gun and be able to fire it and be able to hit the broadside of a barn, basically, to borrow an old saying. Because, I mean, I could tell you when I did mine, I mean, some of those people who were sleeping through that class, I had to stand next to them when they were shooting. And I was like, I'm not sure they know what end the bullet comes out of. And so the fact, and like, I mean, I don't think it's the worst thing to have.
This end, by the way, if anyone is asking, it comes out of this end. This is
Right.
a toy. This is a toy, by the way. It's not a violation of storage law.
Yeah. So I think that that's one of the big things is that, it's making sure that people actually handle guns and also has a written test component, which I think is a good thing because, if you can just sleep through the class, then you get your license to carry and you can go buy a gun tomorrow. You and I talk to clients all the time about this, like the improper storage law. If you don't know how to store a gun, you don't know the basics of firearm safety, then maybe you shouldn't have a firearms license in that situation.
Yeah, it's a serious thing, and I think we've seen enough people get into serious legal trouble over it that it's probably better. Maybe bad for business, but it'd be better if people knew proper storage, if they were required to know proper storage, just so that they don't get arrested when they have to have the police come to their house for something entirely unrelated. Because we know that happens. See a firearm on your kitchen table, no trigger lock, and now you've got a charge. Now you've got a gun charge you got to work through.
Yeah, the improper. So I think that just knowing having some sort of written test, having some sort of accountability was part of this. I do think it's a good thing that people actually have to handle guns. I know that I had to, and I think that Boston had to. You had to go to Moon Island and shoot too, because I've had a lot of clients tell me about that. But yeah, there were a bunch of different things that this 2024 law did. Ghost guns. According to the law, you don't have to prove operability of a gun in a criminal trial anymore. There's this section of the state police that would testify in every single gun trial of ours that, yes, I got this gun, pointed it in here, shot it, and a bullet came out. And they would have to drive around the state and testify to that with every single gun. So you don't have to do that anymore. And obviously there's going to be a lot of litigation. And by the time that this comes out, there may be some new litigation that's come out about it. But the 2024 Act, I feel like it was kind of a reaction, like you said, to the Bruin case. The red flag laws too was another thing that it changed that kind of expanded the red flag laws. Have you dealt with any red flag law cases yet?
I haven't had any clients who've had them. I'm vaguely aware of what it does, but it's, have you seen it in court?
Oh yeah. You can basically go in there like a restraining order and ex parte move or ex parte without the other party present say, yeah, I want to take away this person's right to a gun. And some district court judges, yeah, all right, their guns are gone. And this kind of expands that as well. One interesting loophole that it did stop was that, there are two different kinds of restraining orders. There's 209A and 258E, which is the restraining orders involving your family and the restraining orders involving a stranger. The 209A, the restraining order, abuse prevention order, meant that you surrendered your gun rights if one was issued against you. But there wasn't the same provision under harassment prevention orders, 258E, and actually closed that loophole as well. So I feel like we're 6-7 months, maybe 9 months out from the 2024 law going into effect last October. I don't feel like it's caused as much of a disruption as we thought it would, but it's still something to be aware of. That's changed.
Maybe that it's still the implementation in law enforcement may still be it's, as they learn what they can and can't do, they may follow suit. I think you may see more prosecutions for safe storage issues, right? Because that was something that did get updated, right? Storage requirements. So
how did the storage requirements get updated?
So I think mandating a locked container or tamper-resistant mechanical lock or safety device when it's not under the direct control of the owner. And then again, if I have this correct, it doesn't matter if the thing is unloaded or not. So it's got that, the unauthorized access, which I think is a tough one in family situations. I think I can recall a client who's, for reasons that are not, I think, professional for me to go into right now, lost his license, was suspended. And when the police came to confiscate his weapons, they asked his wife, and his wife went and got them, and she didn't have a license. And so when she applied for a license, they said no, because you had unauthorized access to your husband's guns. Which is kind of a weird, right? It's an interesting, basically accusing him of inadequate storage safety because she could have access to them when she didn't have a gun license.
Yeah, I feel like improper storage is, you can understand why they wanted to do it. You don't want kids getting guns. You don't want people who are unauthorized to get guns. But it's so abused. I had a client who the police were literally pulling up to stop him. And he had a licensed gun, and he thought, okay, well, I don't want I don't want to keep it in my car and the police be worried. So I'm just going to drop it out of my window before they get here. They charge me with improper storage. I mean, and like, it's like, I could sit here and recount dozens of cases like this. I mean, it's so difficult to store your guns correctly. And if you're not, so basically, if you have your guns, they either need to be on you under tamper resistant locks, so like a trigger lock, or they need to be in a safe.
Yeah. And then be careful who has access to the safe.
Exactly. Yeah. I mean, because if the safe could be accessed by other people, then
yeah. Can you imagine now you got to be in court being like, well, it's the safe where we keep all of our like passports. So of course my wife has access to it. Does your wife have a gun license? No. It's like, okay, she had access to your guns. I mean, I get
it. And then all of a sudden I got to have an argument with my wife about, I'm sorry, honey, you can't have the password to the safe. It's like,
yeah, you're going to want to talk about that in our divorce podcast, probably.
Right.
All right. Yeah. So, I mean, I feel, there's a lot in there. We could flog it to death, but I don't know if you want to jump into what we teased about earlier. If you want to talk about Marquis Donnell, you want to keep going through 2024? So
yeah, I think that let's do a quick lightning round.
Oh, good.
What do you think? Is live fire training a good idea?
Absolutely. And I mean, I'll expand on that. The way you phrased it, I think, was perfect. You need to be able to show that you could shoot the things whilst you have the license, right? Like, I mean, what is the point of owning a gun, like a real functioning firearm, if you couldn't use it? You're basically guaranteeing that the only time it will ever come into play is when it gets used against you, which is not what you want. So, I mean, I think I can see arguments that people could make about how, if the police want to, they'll just make this an impossible test and then I'll fail. And, we'll cross that bridge when we get to it. But like, I think for now and we can prescribe like what the bare minimum needs to be. But I mean, to the extent too, that you want people to be able, who have a license to carry, to be able to safely handle a firearm. Like, I'm all for, an armed society is a polite one and a safe one, but that's not really true if a person can't handle a firearm without shooting it accidentally. I may have gone overboard there, but I think it's live fires, even though it's another step and more government intrusion on the right, I think that it's merited here.
I don't feel like you haven't seen lightning before, because lightning is a lot quicker than that.
I'm taking a lot of liberties with it, because when we did the divorce round, I said, give me yes or no answers, and you just went. So now I'm going to do the same thing. Let's try a faster one.
All right. What do you think about the written test? Should LTC applicants have to prove that they know the safe storage requirements?
Yes. Because if you can't repeat it, then why would we think you would store it safely? The underline here is like responsible. I'm all for responsible gun ownership. And I think that there are limits to how uninformed you can be and still be responsible. So
what do you think about, there are also we didn't touch on this earlier, but about record keeping for gun sales. So do you think that gun dealers should have to keep those permanent records?
I think this is a tough call, but as someone who worked in prosecution for a while, I think that you do need to be able to keep track of these things, because there's a big market for underground firearm sales. And if there's no obligation to keep records, I mean, and Second Amendment advocates want to say, look, the answer to a bad guy with a gun is a good guy with a gun. How many bad guys with guns do we want? Because they are, without this record keeping provision, and I understand concerns about surveillance state, especially where our information, I'm failing the lightning part of this, but I think, my answers are not ill-considered anyway. I want people to think I'm just shooting from the hip, lightning style.
Yeah.
Go ahead. Next one.
Yeah, I mean, I do feel like there's a certain worry about Big Brother here. We don't want the government going through and figuring out who all the gun owners are and what they have necessarily. But yeah, $100 for an LTC application. Do you think that's too high, too low? What do you think?
Too high. Shouldn't have to pay any amount of money to exercise your rights, especially where there's so many hurdles to jump through.
Yeah, so that's the next question. Do you think that this law targets responsible gun owners too much?
I don't know if it targets responsible gun owners. I think, and no, I don't think this targets responsible gun owners. I think that when you look at this, it's largely attempting to close loopholes that people have tried to exploit. And what is a loophole besides a clever way around the law? Right? It's not an attempt to follow the law. The law hasn't caught up with you yet. It's like, but if I do this thing, I get to have my machine gun and you can't stop me because it's a clever legal trick. Is that really messing with people who just want to exercise their rights responsibly?
I think the worry is that by having so many rules, the rule followers are going to follow them. The rule breakers aren't going to follow them. So, I mean, I do think there's a balance between those two things.
Sure. I don't disagree with that. I will say this. I think we did talk about this earlier, right? Where the law may be a response to Bruin, there is a federal movement towards greater individual liberty when it comes to Second Amendment rights. And this is maybe it's a counterbalance, maybe it's an overreaction, but it's these two things are moving. It's not like everyone is making it harder to get a gun. The feds are making it easier and the state's making it harder.
Yeah. So currently LTCs are valid for 6 years. Do you think it should be longer than that?
Yeah, because boy, if that thing expires and you're not paying attention, woohoo. No, this is, I think the concern I have genuinely, and look, it could be longer. Why make it shorter? Maybe there shouldn't be a swinging penalty for if it, there should be a grace period for getting it back.
Well, there is, if it expires, it's just a fine, I think, for having a gun. It's not like you're looking at 18 months.
That's fair. I don't want to pay a fine either, though, just because I'm absent-minded. Yeah. You know what? No, keep the 6 years, but now we got to have driver's licenses need to be wrapped every 6 years. Take a driving test every 6 years.
Yeah. All right, so let's move on to two cases that came out earlier this year, Marquis and Donnell. So these are really cool cases because I remember when it happened, it was the presiding judge in Lowell, Judge Coffey, basically got tired of all these people from New Hampshire coming down, and New Hampshire is basically the Wild West when it comes to guns. Like I think that, don't they give them out at the hospital in New Hampshire when you're born?
Yeah, generally speaking, the rule in New Hampshire, I was a prosecutor in New Hampshire for about 4 years, and I think what you need to have a firearm in New Hampshire is a pulse, and even then, it's like, I think, and there are obviously the federal law still technically applies, but we as a prosecutor in New Hampshire, it was wild. I think they did away with some of the last lingering state restrictions on firearms while I was a prosecutor there. So
yeah, and like this,
yeah.
So in this, Judge Coffey, basically one of the things he talked about is that there's actually a mall that is, one part of it is in Massachusetts, one part of it is in New Hampshire, and a New Hampshire resident could legally carry a gun in one part of that mall. If they carry the gun in the other part of that mall, 18 months in jail, felony. And he just said, it's one of the most amazing opinions ever, because he just said, that's ridiculous. That's really unconstitutional to say that because I crossed this border, something that is basically encouraged in one state can lead me to a mandatory minimum 18 months in jail in Massachusetts. So then in 2025, there are these two cases that come out, Marquis and Donnell, that are challenging the Massachusetts licensing scheme. I remember I was super excited when these cases were coming out, because I thought that the SJC was finally going to have to say, yeah, this whole suitability stuff is not constitutional, but it seems like they avoided that.
Yeah, they went some of the way, but not the whole way, right? They added some new language, but they didn't throw the whole thing out.
Yeah, exactly. So what's the difference between Marquis and Donnell? Donell wins, Marquis doesn't. What's the difference between them?
So the key difference, I think, in the way the court evaluated these, right, is that Donnell's case is prior to the 2022 legislation that was itself a response to Bruin that, turned us into a type of shall issue from where we were a may issue, right? And so the court, without skipping a lot of the legal niceties, in Donnell's case, they basically say the may issue did not comport with Bruin, and it existed after Bruin. So this guy was being punished for under an unconstitutional firearms licensing regime. And so he wins. Marquis, however, is he's in the post-22 era. So he's in the shall issue era. And so there are some kind of procedural reasons why he lost in a way that may have helped him. But fundamentally, the regime, the court basically says, when you change the law, you did it right. So we're not going to. So where we punished the government in Donell for not following Bruin closely enough, in Marquis, we're going to give the government some credit. But there are, and it does get more complicated than that. And I don't know if you want to dig into them more. I do think that one of the bigger takeaways is, because I take your point, they didn't get rid of suitability entirely, but they did qualify it, right?
Yeah, they said that basically if you have a system where there are you have to have credible evidence of a public safety risk, then the chief can deny you on suitability grounds. Legally, it did, I feel like, change it from the sort of freewheeling nature of what suitability was before. And I think in the Donell case, too, I mean, it was like they were both out-of-state licensed. They were people from New Hampshire. And if Donell wanted an LTC, basically the statute said that the colonel of the state police can deny it based on such terms and conditions as said colonel may deem proper. Like basically unlimited discretion. Like, hey, the colonel of the state police, doesn't like your hair, he can deny you an LTC. So at least there's some like outer limit to what suitability means in that context. And then in Marquis, they're like, oh, but this is very different. It's shall issue. And there are these guidelines about public safety. But from litigating these cases, I mean, I can tell you it's not that much different from we don't like your haircut.
Right. I was going to ask you that because you very carefully were like, yeah, they put a bunch of legal prescriptions around it. But practically, what we're seeing in the district courts when you appeal a license to carry denial is that the courts, I mean, I'm not going to name the judge to throw them under the bus, but have them citing to the Karras decision, which is from a lower court than the SJC and is older than Marquis and Donnell, because it's kind of like, Marquis and Donnell did not override Karras. All it did is say we have to be a little bit more, the police have to have something more specific about their gut feeling against you.
Exactly. And it's like, oh, now, like suitability, for those who don't know, basically, even if you don't have any convictions that prohibit you or anything else like mental health, involuntary commitment, or dishonorable discharge from the military, the police can say, well, we don't think you're suitable for a license to carry. And it can include things that were dismissed. It can include things you were found not guilty of. It can include charges that were never issued. It can include restraining orders that you didn't even have a chance to contest. Anything and everything can factor into that suitability decision. And the idea that we have shall issue, but they have to be suitable is somehow some restriction is ridiculous, because in realistic terms, like making a mistake on your application can mean you're not suitable. What is the connection between, hey, I forgot that back in 1986, that case that I had, it was a guilty vacated instead of a, continuous without a finding. Like I make that mistake on my license and the police deny me. I don't know.
Safety risk. Yeah.
Yeah. Like it's supposed to be grounded in this public safety risk, but you talk to judges and everything is a public safety risk. Like that's the problem with having any discretion with these things. And that's the reason why we don't have discretion when it comes to your right to vote, your right to free speech, your right to go to the church you want. Like you say what you want about Justice Alito, but he has this great line. It's like the Second Amendment is not some like secondary right in the Bill of Rights. It's not some one that's like, oh, well, yeah, the founders really meant all the other ones, not the second. And it drives me crazy, like all the things that they find you not suitable for. Like I talk to people every day about this kind of stuff, and the idea that, oh, well, you're not suitable because you forgot this case that you had, or you're not suitable because of this, that, and the other. And all of a sudden the SJC just blesses this regime as, oh, well, this is like, there are very strict standards on this. It's like, no, there aren't. This is like the current system is the same as the system Donell applied under, but they just don't have the guts to say it. And that's the problem with doing any discretion. That's why we don't have discretion in the other constitutional rights.
I mean, it's like I said at the very beginning when you asked me the difference between may and shall, and I said shall means there shouldn't be, right? Unless there's some disqualifier, some legal disqualifier. Anything that's shall softly is probably just may again, right? It says not a shall, but yeah, it's a tough situation to be in. I've seen people get denied and not be able to restore their licenses because the judges are just, they're comfortable with the articulation from the police department that this person's a public safety risk because of that case that got dismissed 30 years ago.
Yeah. So, I mean, I thought that we were going to make, and maybe I guess I haven't talked to the people who are representing Marquis in this case about whether they're going to apply for cert with the Supreme Court. But if you start saying that you have a Second Amendment right that is just the same as any other right to have a gun, and then you start saying there can be this discretion involved in it, then you start just opening Pandora's box. I feel like you just start getting to the place where, like, what level of discretion, like how do you make that decision, right? Like if making a mistake in your application is considered a public safety risk, what isn't?
I don't, I think it's guidance to the district court judges, because the regime we're in is that the district court judges are supposed to be able to say, we find that this does not pass constitutional muster. This was not a reason to deny someone's an LTC. And it seems like they sort of just bless. I mean, I don't want to throw all of I'm sure some of them uphold the right when it's appropriate, but there seems to be a lot of deference given despite the changes we're seeing federally. So,
yeah, I mean, I can tell you, I've represented people who've had cases from 30 years ago that were dismissed and have been denied for that reason. And it's still been upheld by every level of the court. Oh, this is a public safety risk. But it's really just deference to the police, which is, if we have a constitutional rights at deference to the police, then we don't have constitutional rights. I mean, imagine if they were like the Fourth Amendment was just, yeah, you have the right against unreasonable search and seizures at the discretion of the police. Then you don't have that right anymore.
I wouldn't especially, but I take your point. The Fifth Amendment might be another one that you wouldn't want to lose to that. The Eighth.
Yeah, like
just keep going.
I think there were a lot of other interesting issues in there that the court kind of sidestepped, potential future issues. Like they kind of bless this idea that you can treat residents of your state and non-residents differently, right? So if you are applying for an LTC and you're a Massachusetts resident, you apply with your local police, whereas you apply with the state police if you're out of state, and there's a completely different process, completely different presumptions. And I feel like they bless that here too, which in a kind of troubling way. And then there was also some other issues, like they mention the delays in getting an LTC. Do you remember when that part came up?
I'm all hung up on standing, but Marquis and his standing problem, but we're not talking about that.
Yeah. So like Marquis, there's this line about if a lengthy wait time to get an LTC may actually deny your constitutional rights.
It seems appropriate, right?
But it's like, well, what does a lengthy wait time mean? I mean, it does kind of give us some more things to potentially litigate in the future. But yeah, like the 90 days they said wasn't automatically unconstitutional, but there might be something in the future. I mean, I've seen people wait so long with some of these towns to get an LTC that there could potentially be issues there. But yeah, I mean, I think we've just kind of scratched the surface here, Chris, on what changed in Massachusetts licenses to carry since in 2024 and 2025. And I'm not sure if we've really settled anything, but I think it's just useful to know that there's some other stuff out there that we should pay attention to.
No, I agree with you. And I mean, this is it's an issue that affects a lot of people. And I feel like the guidance and clarity on it could always be better. Someone should write a book. Maybe it could be you, Matthew.
Yeah.
We'll see. Anyway, I really appreciate you having me on. Always love to be on Boston Barristers. So
yeah, well, you are a Boston Barrister, right? So you have to be here.
Fair enough. But I'm not going to be on every single one. You got to have Bill back here at some point.
Yeah, definitely.
Some of the other great barristers in the Boston legal community.
Yeah, definitely. Thanks for joining us in another episode of Boston Barristers. Just keep in mind that what we've given here is not legal advice to your particular situation. You should consult with a lawyer about your particular situation before making any decisions. We tried to do our best to outline the basics of the law and how it's changed recently, but always do your own research and always consult with an attorney about your specific situation before diving in. All right. Thanks, Chris. Enjoy the rest of your day, man. Thanks for coming on.
Thanks, Matthew. Same to you.